Coming to a marriage with separate property or inheriting separate property during a marriage has different ramifications for divorce versus inheritance. The concept of separate property is a divorce term. It is not an inheritance term. And so what can happen will be different based on what happens within your marriage. So if you pass away, the surviving spouse, if you're still married, will be entitled to a percentage of your estate, regardless if it's marital or separate property. Now, if you divorce, the separate property will always stay separate and not subject to equitable distribution claims. What many people don't realize is North Carolina has the elective share, which entitles the surviving spouse to a portion of your estate, no matter what your estate plan or no matter what your beneficiary designations say. That interest starts at 15% and can increase to as high as 50%, 50, after 15 years of marriage. And so regardless of what your estate plan says, or whether the property is marital or separate, that's a right that your surviving spouse is going to have that they can elect within 6 months of your date of death. And so consideration around assets and how it's held also needs to embrace the concepts of prenuptial agreements or post-nuptial agreements to carve in and out what sorts of inheritance rights we want to give to each spouse.